in the Philippines, there are 4 instances in the revised Penal Code of Criminal Procedure, revised rules of criminal procedure, where probable cause is needed to be determined. 1. In Section 1 and Section 3 of the Rule 112, the investigating prosecutor or officer to determine whether there is sufficient ground to engender a well-founded belief that the crime has been committed and the respondent is probably guilty thereof and should be held for trial. A preliminary investigation is required before the filing of the complaint or information for an offense where the penalty prescribed by law is at least 4 years, 2 months, and 1 day without regard to fine. So this is an instance where there is a need to conduct preliminary investigation. Sir, pero ang sinasabi mo, hindi kailangan ng preliminary investigation under the following instances. What I cite is the general rule. I repeat, the general rule, you need to conduct preliminary investigation when it 4 years, 2 months, and 1 day. That's the penalty attached to the crime. Now, let's go to the exception. So, like what I said, instances when there's no need to conduct preliminary investigation. In case of warrantless arrest under Section 6 of Rule 112. Okay? What you conducted here is not preliminary investigation, but an inquest proceedings. Another class. In case of Section 5B, by a peace officer or private person making a warrantless arrest when an offense has been committed and he has probable cause to believe, based on personal facts or circumstances, that the person to be arrested has committed it. So that is an instance, okay, of what we call no conduct of preliminary investigation. Another class, in case when the Honorable Court issued a warrant of arrest. That is another instance where there is no need to conduct preliminary investigation. Naturally, because the court, the prosecutor has already conducted preliminary investigation. Another is in Section 4 of Rule 126. Okay? When the judge issued a search warrant, there is no need to conduct preliminary investigation on the part of the prosecutor because here, class, the one who conduct preliminary examination is the judge for the determination of probable cause. Officers authorized to conduct preliminary investigation, of course, you know this, provided by express provision of the rules of court, of course, the provincial or city prosecutor and their assistants, the national and regional state prosecutors, the other officer as may be authorized by law. We are referring to the COMELEC and the Office of the Ombudsman. Plus, the first level court judges are no longer allowed to conduct preliminary investigation because of the Administrative Matter 05-08-26, which took effect on October 3, 2005, removing the first level court judges as one of the officers authorized to conduct preliminary investigation. They have been deleted. So, I'll continue, class. Procedure for cases not requiring preliminary investigation. Let's take this one. When the penalty attached to a crime is less than 4 years, 2 months, and 1 day, there are two ways of initiating criminal action. First, by filing the complaint directly with the office of the prosecutor. Two, you can file it by filing the complaint or information with the municipal trial court. These are called direct filing. But remember, class, in case of in Manila and other charter cities, the requirement is that the filing of the complaint, must be made before the proper officer for the conduct of preliminary investigation. That is the rule on offenses where the crime committed is attaches the penalty of 4 years, 2 months, and 1 day. Okay, another question, class. How do you institute a criminal action? There are two ways of instituting a criminal action, either by a complaint or an information, by filing it before the proper officer or the municipal trial court. So there are two modes of instituting complaint or criminal action. One is that by filing a complaint directly with the prosecutor office or before the municipal trial court. That is the rule. Now, when preliminary investigation is not required, even if the offense is one which normally requires preliminary investigation. Well, class, if that is the question asked, you determine first whether the accused or respondent is arrested without warrant. Because general rule, if the offense committed attaches the penalty of 4 years, 2 months, and 1 day, and the proceeding is regular filing, then there is a need for preliminary investigation. But in case of warrantless arrest, there is no need to conduct preliminary investigation. But what they need is what we call the inquest proceedings, conducted by the inquest prosecutor. So that is the rule, class, instead of preliminary investigation. I repeat, if the accused is arrested through warrantless arrest, there is no need to conduct preliminary investigation, even if the crime committed is more than 4 years, attaches the penalty of more than 4 years, 2 months, and 1 day. Why? Because the proceeding to be conducted is an inquest proceedings and not preliminary investigation. Sir, you said that there is no preliminary investigation in case of warrantless arrest. Can the person arrested without warrant request for preliminary investigation? Yes, he can do that. However, he is required to sign a waiver for violation of as provided for under Article 125 of the Revised Penal Code. This is we are referring to the reglementary period of delivery of a person. That is 12 hours, 18 hours, and 36 hours in the delivery of a person, so that the officer in custody of him cannot be charged of arbitrary detention. Sir, assuming that he availed himself of that preliminary investigation, even though he was arrested without warrant, or his arrest is in the form of warrantless arrest, the question is, how many days does the prosecutor must resolve the preliminary or must terminate the preliminary investigation? The prosecutor must conclude or terminate his preliminary investigation within 15 days from the time the accused or respondent has signed the waiver. In short, from the time he was arrested, he must complete or terminate his preliminary investigation. This is in consonant to the right of the accused for speedy trial and speedy disposition of cases and right to due process of law. Because preliminary investigation is part of a due process of law as enacted or as stated in RA 7438, right of the accused or law providing for the right of the accused. Sir, can the accused who has been arrested without warrant post a bail, notwithstanding that there is a pending preliminary investigation? Yes. Okay? If the crime he committed is a bailable crime, he can post bail, notwithstanding that there is a pending preliminary investigation and that he signed a waiver. Because there is no provision in the law that would prevent him from filing or posting his bail for provisional liberty. Take note, while a preliminary investigation is undertaken, the person arrested is still under detention. To effect his release, he may apply for bail notwithstanding the waiver, of the provision of Article 125. And even if no information has yet been filed against him, he has the right to bail, as it is supported by Section 6, Rule 112, in relation also to the provision on 114 on the right to bail. What is Section 114? Section 17C. Any person in custody who is not charged in court may apply for bail with any court in the province or city or municipality where he is held. So that is the reason why, even if there is no case yet filed, a person who has been arrested without warrant can immediately post bail at any time, because of this provision on Section 17, Paragraph C, Rule 114. Another question, class. Is the absence of preliminary investigation for cases where the imposable penalty for the crime, where the penalty attached is 4 years, 2 months, and 1 day, a violation of due process, and that the accused may file a petition or a special civil action before the Supreme Court for violation of his due process? The answer is on the affirmative. Because like what we said, preliminary investigation is a statutory right and a substantive right. It's not only a mere technical or formal proceedings, but it is a substantive and statutory right, class. Now, sir, there is no preliminary investigation, but the accused failed to raise the preliminary investigation before he enters plea. Now, can he still raise that? No more. Take note, the principal, class. When the accused enter his plea, he is deemed to have waived his right to preliminary investigation, because he must invoke that preliminary investigation before he enters his plea. Another, class. If a person warranted illegally arrested did not raise the issue of illegal arrest before his arraignment and he already entered his plea, that defect or illegal arrest will now be deemed waived, class. The illegal arrest will be deemed waived